Good afternoon. I'm Rob Massa. I'm the Managing Director of Qualified Plan Advisors in Houston, Texas. I'm also known as the Retirement Pro, the Foracle, or the 401k Guru. I want to welcome you once again to my blog. Today, I'd like to take some time to talk with you about partial plan terminations. It's actually evolving into a big challenge for employers that sponsor retirement plans. This happens a lot when you're dealing with a lot of reductions in force. So I'd like to review some of the items employers need to consider when faced with employee layoffs and group terminations. First concept is to review defining the employment status of your employees. So is an employee a furloughed employee, or are they laid off or terminated from employment? The first of these statuses would be a furlough. Now, a furlough is a temporary layoff from work. People who are furloughed usually get to return to their jobs after the furlough period ends. Furloughs are often characterized by a reduction or even suspension in working hours and pay. Employees are still employed and they're even eligible for benefits, but they may not have enough money in their paycheck to cover the cost of these benefits. In these cases, no separation from service has actually occurred. In contrast, in layoffs or reductions in force, RIF, it's a formal termination of the employer-employee relationship. While layoffs imply that employees may be invited back to work at a later date, RIFs don't necessarily have that same implication. Also, employers are no longer eligible for benefits. Employees may only be eligible for, say, COBRA. Now, when layoffs or RIFs occur, we need to be cognizant of how many employees separate from service as a percentage of the total workforce. That's because when too large a percentage of the workforce is terminated, we may have a partial plan termination, and the retirement benefits of these employees then become 100% vested, which leads to this question: when might a partial plan termination actually occur? Now, general rule of thumb under IRS Revenue Ruling 2007-43 is that if more than 20% of your workforce has involuntarily separated from service, you're assumed to have a partial plan termination. So does that mean if less than 20% terminates, you don't have one? Not necessarily. What the rules say is that if more than 20% of the workforce is terminated, you're subject to what they call a rebuttal presumption under the law, which means you are assumed to have a partial plan termination unless you can prove otherwise, i.e., essentially, you're guilty until proven innocent. Now, if less than 20% of your population are terminated, you're presumed not to have a partial plan termination, but in an IRS or DO audit, they could rule otherwise. A partial plan termination situation is basically a facts and circumstances test, and you're going to have to work through the various information. Now, as always, here are a few things to keep in mind. First, understand that multiple layoffs or RIFs can be aggregated together when determining the 20% threshold. Each layoff or RIF that can be tied to a single related corporate event enables those separate RIFs to be aggregated together and calculated as one. For example, if a business suffers an economic downturn from COVID-19, well, that's a related corporate event, right? And all 2020 layoffs, let's say, or in RIFs, may tie back to that event. Next, you got to think about the determination period. Generally, the plan year is your basic determination period. But that's not a firm rule that you can hang your hat on either. For example, let's say to avoid that 20% threshold, I lay off 12% of my workforce on December 30th of 2020, and then in January 1st of 21, I lay off another 10%. I can promise you that's not going to fly. Determination periods don't have to be limited to a calendar year, a plan year, or even a 12-month period. Again, it ties back to the related corporate event standard. Just keep that in mind. Another thing to consider is what happens when you aggregate multiple RIFs and they total more than 20% of your workforce. Well, in those cases, you'll need to retroactively vest all of your employees affected by the various RIFs. Now, this can become a real problem if in the interim you've used all those unvested forfeitures to pay for other plan expenses. Now you're going to have to restore those forfeited amounts out of the organization's general account, and that could come at the worst possible time for the finances of the corporation. I'd like to thank you for visiting my blog again. I hope that you found this latest installment useful. If this is your first visit, please check out some of my other content on my YouTube channel. If you need more information or any assistance on any retirement plan related matter, reach out to me LinkedIn at Rob Massa, or you can email me, rmassa@qualifiedplanadvisors.com. And as always, I'm wishing all of you a very successful retirement. Thank you.